looks like we can go ahead and get started if you want to greet our guests, and we'll kick it off.
Hi, everybody. Thank you for coming. We love artists, and we are very happy today to have this Protecting Your Creativity forum. And we have some very special guests here. My name is DeAndre Nixon. I'm the founder of In Education and the founder of the Battle of the Teal program. This is a Teal forum. Welcome all. I hope you enjoy, and we'll be following up with you after. Thank you.
Hi, so I'm going to take it from here and kick off and introduce our panelists. My name is Jessica Payne. I am the Director of Community Programs at the Cleveland Metropolitan Bar Association. I am also very proud to be staff liaison to, among many programs that the bar puts on, the Volunteer Lawyers for the Arts. This is an organization that has been around since 1972. It is a group of attorneys who want to give back to the arts. Their mission is to encourage a vibrant and thriving arts community in Cleveland, and they do that through knowing that the arts community often is going to need some legal help along the way. So they are proud to give back through either participating in public education forums, such as the one tonight. They also do handle pro bono applications for legal help. So if you are an artist or an arts organization in Northeast Ohio, the greater Cleveland area, we definitely encourage you to reach out to us. I'm going to put up my email address and the Bar Association's website, how to see more about the Volunteer Lawyers for the Arts. We call it VLA, so if we use that acronym, you'll know what we're talking about. Please do reach out to us if you would like a speaking engagement or you need some legal help. We are always happy to pitch in. So with that, I would love to turn it over to our wonderful panel tonight for Protecting Your Creativity. The VLA, as I mentioned, does presentations like this numerous times throughout the year. This is our second since the COVID shut down, going over Zoom. So we are glad that you can join us tonight and hopefully find this as informative as we would like it to be. So one of the things the VLA does is talks to students and people early off in their careers and helps them with the basics of how do you get going. Ounce of prevention is worth a pound of cure. So if you know how to protect your creativity and avoid violating other people's rights, you are automatically going to be in a much better situation, which is why we're bringing this to you here tonight. We have our three wonderful panelists, and I'm going to introduce them in the order that they are going to be speaking. First off, we've got Ed Caja, who is an attorney from Walter and Haverfield, is a local law firm in Cleveland. He is going to be talking about intellectual property law. And Ed is, prior to joining Walter Haverfield, he developed what we would call a well-rounded aptitude for innovation counseling, and he has experience in various legal, business, and technical management positions across many organizational roles. He also, of course, includes in his expertise patent application preparation and prosecution. His legal experience also includes litigation assistance involving patents, trade secrets, business torts, and unfair competition in numerous arts fields. If any of those terms don't sound familiar, have no fear, Ed's going to talk about them. Next, we've got Clare Shin. Clare is currently a law student at Case Western Reserve University School of Law, but has a lot of experience in speaking and research in the law. So we're so excited to have her join us on a field and a topic that we haven't had much presentation in the past, but it is something that is very important and is developing even more and more today. She is a third-year law student currently studying in Paris. Right now, she's currently in Paris. So thank you for joining us late in your evening, Clare. She is the co-president of the Sports and Entertainment Law Society at Case Western Law. She plans on being a fashion attorney when she graduates in 2021. And her article, The Future of Fashion Law in America, Copyright as the Key to Creativity, has been published in an international fashion law journal. She's also a guest speaker at the Kent State University Fashion School. Last, but of course not least, is Katie Steiner, who is an attorney with Hahn Lozier Parks. She is our current chair of the VLA committee for the CMBA, and she has handled multiple speaking engagements and pro bono representation as her way of giving back to the local arts community. Katie's practice focuses on nonprofit law, art law, litigation, and intellectual property law. And she's assisted national brands with patent and trademark litigation and enforcement, especially in online marketplaces. Her commitment to arts clients stems from her previous professional background, where she served in museum curatorial positions at the Metropolitan Museum of Art and the Frick Collection in New York City. So we couldn't be more pleased to have these three joining us. What I'm going to do is kick it off first to Ed, who's going to give us an intro and lead us into our topic tonight. But before I do so, really quickly, I'm just going to say to everybody, please, although our presenters are going to be giving us information, I very strongly encourage you to use the Q&A function in Zoom down at the bottom of your screen. We will be watching for that. We'll either incorporate it in if it's appropriate as our speakers are talking, or we're also going to reserve some time at the end to answer any questions that we haven't gotten to yet. So please use that liberally. We want to hear from you. We don't want this to be a straight up lecture. We would love to have some questions and answers and really be as useful as we can for you. So with that, I'm going to kick it over to Ed. Thank you very much. Ed, you're going to want to unmute yourself.
That and capture the share the screen properly. Hopefully people can see the screen, even though it says my internet connection is somewhat unstable. First off, I wanted to say that I am humbled to be among creatives. I grew up in a large family, but I tended to be a techno geek type of person with very little what I would call creative skills of my own, although I appreciate them in other people. One of my dearest brothers was an artist in San Francisco, and he has material in the Smithsonian, and in a strange way I can claim fame that I am mentioned because his audio history includes me by name. So in a sense, I am in the Smithsonian. With that being said, everyone loves acronyms, right? CMBA, VLA, PDQ, IANYA. Does anyone know what these are? Does anyone care to guess? Open for guesses. Actually, it's Cleveland Metro Bar Association, Volunteer Lawyer for the Arts. Jessica kind of gave that away. Pretty darn quick. This is a very, very broad overview, and I am not your attorney. The reason why I say that is twofold. One, I am not your attorney. This is not a client-attorney relationship. And two, it's important that you do not assume that you have attorney relationships. Attorneys are bound by strict codes of ethics, but you should not be making any assumptions, and you want to try to get your agreements in writing. With that being said, I will continue here. So these are what I'll cover at a very quick pace here. Some simple laws. What do you want? What do creatives want? Some simple caveats to the laws of intellectual property. Some not so simple caveats. Some trade-offs and some simple suggestions that I will give for you to go to the source. Intellectual property. Different laws for different things. Intellectual property is a very broad concept. It covers a bunch of different things. Here you could see patents and patent pendings. The C in a circle is copyright. The R in the circle and the TM in the circle are registered trademarks and trademarks in general. And I put that little warning sign there for trade secrets because they're kind of a secret, but nonetheless, potentially powerful tool for people to have in promoting their business. So the different laws for different things, that each form of IP is intended to protect different things at a 10,000 foot level. Patents are meant to protect utility. You have something that does something. You have a method of doing something. You have a chemical or a drug or a device that does something. So patents are protecting utility. Copyrights, on the other hand, protect expression. Expressed ideas in film, in music, in a bunch of different areas, but copyrights are meant to protect expression of ideas. Trademarks are there to protect both businesses and the public from business confusion. On the business side, you're able to protect your identity as a particular source of a product or a service, and that gives the public a notice of the quality that you intend to have with that mark. Other people cannot do things that are confusingly similar to that, and that's where the protection comes from. The public is protected in that when they go and they see a mark and they use it, they know that they're getting it from the registered or otherwise trademark holder. Trade secrets, I put that purposely in kind of a hushed tones there. Trade secrets protect developed know-how. Those are internal to businesses, and the consuming public generally is not aware of trade secrets. One aspect in all of this is you really look at this from you personally and professionally, understanding your own plans. There is no single reason why any of these intellectual properties are good or bad, or you should get them or not get them, and they all depend on what you're trying to do. When I counsel individual people, I look at risk and reward. And for myself personally, I came from a couple different areas. First, I was an engineer type, then I went back to school, got an MBA, was in the management type. So for me, the easiest way to look at this is business plans. What are your business plans? What are you trying to do? What are your risks? What are your rewards? Where do you want to spend money? Where do you think you'll be getting money? Understanding that, and as your intellectual property fits into that, is probably the most important. Not planning is planning to fail. As I mentioned at the beginning, the first major simple caveat is I am not an attorney and this is not legal advice. And why I say this, as I mentioned, attorneys operate under a strict code of ethics. New clients mean sometimes that I cannot take other clients because I have your interest at heart. So when you're talking to an attorney and you're wanting to tell them everything, attorneys will be a little perhaps standoffish. That is not to be impersonal. It is to protect you and to protect them. Money, and why bother? Again, this goes to the business plan. Money is the root of property portion of intellectual property. And therefore, that's one of the drivers and simple caveats here. In a nutshell, copyright is probably the easiest to obtain, but carries the thinnest protection. I know that our other speakers will talk a bit more on copyright, but just at the simplest level, copyright is very easy to obtain. Patents are perhaps the most difficult to obtain, but they also may serve as the strongest. But even this has its own caveats, because sometimes what was once a strong patent changes over time because of what the courts or what Congress may do. Then might be worth an explanation. Then is, for example, fair use is a good legal concept. You may have a copyright, but that doesn't mean that you can prevent anyone and everyone from looking at or using or referencing your copyright. There's a number of different factors in fair use. It's very fact intensive, and it gets very deep into the legal weeds very quickly. So on simple caveats, I'm not going to talk too much more about it. On the strong side for patents, patents are like trespass. Intent is not required to have a transgression against the patent. Knowledge is not required. So you may be, doing something or creating a utility all happy on your own, and all of a sudden someone may come knocking on your door and say, you cannot do that because I have a patent on that. And they would be correct. So there are items of patents and strengths in businesses. If you are planning to scale up and spend a lot of money in a certain business area, it might behoove you to do a patent search and a clearance search so that you know that you're operating without stepping on someone else's intellectual property. On the trademark side, trademarks and trade secrets generally are more intricate from a legal standpoint, with state by state as well as federal law effects. Trade secrets generally fall into the same type of areas of trademark law, but does have some intersection with patent law. Again, as I mentioned, the simple caveats here is these are meant to protect both the source and the purchasing public. And that's probably the best takeaway from the trademark side is that type of protection. Secrets obviously do not protect the public, but have historically been opposite the goal of patents. So as a patent attorney, I tend to frown upon them, but that's more from a philosophical point of view. I do not frown upon them because that's an important aspect that my clients might need and use in protection of their business. So some of the not so simple caveats. For all of the creatives that not pay attention in civics and other boring classes while growing up, yeah, this is where it gets not so simple. The legal basis of protection and the government in general. I promise this won't be too painful. At the top of what I'm calling this pyramid here is we the people. That's the Constitution. It is the source of all of our laws. Down at the bottom is the actual people, and in between you have all these layers and policies. Layers and policies include both federal and state governments. We actually live under two different sovereigns. I'm not sure many people realize that. State rights may provide differences, especially in areas of what are called non-preemption. Patents and trademarks are preemptive. States do not have patent systems. States do not have copyright systems. Only the federal government has each of those. Copyright systems, though, may be state-based, may be regional-based, so that makes it a little bit more tricky. Also, as far as we the people, the other historical item, the Declaration of Independence, interesting note there. Life, liberty, and the pursuit of happiness is the catchphrase of the Declaration of Independence. That actually stems from a slightly modified phrase of life, liberty, and property. The intellectual property has a strong tie to the beginning of our government, based in some of those concepts there. So the not so simple concepts on the legal basis of protection for patents and copyrights is Article 1, Section 8, Clause 8 of the Constitution. There won't be a test. You don't have to remember that. The examination and general requirements, there's keep outs, what you may or may not be able to do or protect. Again, I'm going to broad brush stroke this. These are just to give you the kind of a flavor for the fact that these things can get complex pretty quickly. As I mentioned, this is a power that stems directly in our Constitution. The Bill of Rights, which I'm sure everyone is aware of as far as the First Amendment and your freedom of expression, is actually an addendum to the Constitution and comes after Article 1, Section 8, Clause 8. In general, patents for eligibility are types of things. Other general requirements are novelty, non-obviousness, enablement, and possession. Each of these are legal terms of art, and I won't go into too much, but I'll give you a hint at the end of where you can actually read up on some of this at your leisure. In copyright, original work in a fixed medium and creative expression are the general requirements. In the keep-outs, patents have many, and they're typically related to those requirements of type of eligibility, novelty, non-obviousness. The keep-outs on the copyright side tend to also reflect the fixed and intangible medium, original creative, which though it tends to be a low bar, and non-functionality. The legal basic protection for trademarks, trade dress, trade secrets is a little bit different. It actually comes from the Commerce Clause, which is Clause 3. Again, there won't be a test, so you don't have to worry about remembering that too much. The thing to remember here is that the Commerce Clause is actually a federal power to regulate commerce between the states. It is not preemptive. It is state to state. If you operate something that's completely within a state, you may not be as affected by this. So again, preemption tends to be less here. Trade secret does have a federal registration power that they've wanted to put in. Trade secrets are moving that way, although it's not preemptive right now. So a lot of the stuff is a little bit more complex, actually, because there's not a single government basis for these types of items. Trademark general requirements, actual or intent to use in commerce. And of course, the most important one is distinctiveness, or the ability to distinguish source. There are a number of keep-outs based on those concepts. Trade secrets, the important thing there is business value added, measures in place to protect secrecy. Once legitimately known, trade secrets can become largely unenforceable. So that, a very key part of the trade secrets, and if you're involved in litigation on trade secrets aspect, is what were the measures you took to make sure that you maintain secrecy. On trademarks and the keep-outs, notably keep-outs are confusingly similar marks, misdescriptive marks, and generic marks. And I'm sure our other speakers will touch upon those in more detail and more interesting detail. Trade secrets, there's not many keep-outs, but you must maintain and must provide business value. Trade-offs. I included a little circles, and then I pushed the circles apart so far they didn't even show up on the thing. Generally speaking, a lot of people look at the three areas of patents, copyrights, as trademarks as having no overlap. There are actually exceptions to that rule, which makes them for interesting legal discussions for geeks like me, and unfortunately for some people who get caught up in those legal snares. So again, that's a very intricate part and not part of this, but be aware that even though most people do talk about them as being completely separate, there is possible overlap. Patents, like I mentioned, are powerful but typically expensive. Copyrights are easy but have thin coverage and are probably the least expensive. And trademarks are tied to legitimate business. And the actual use in commerce, intent to use in commerce, those are important aspects of trademarks. Trade secrets, a variety of complex issues, but potentially unending protection. As long as you can keep it a secret, you can keep it a secret. It's a trade secret. The notable thing on all of these items is that each of these are up to you to police and enforce. Some people get a patent, they pay a lot of money for the patent, and then they are puzzled when they find out that someone's violating their rights. And it's like, well, what happens? It's like, okay, you get to sue them. You get to spend money to enforce your patents and copyrights and trademarks. Not the government. The government will give you these, will give you the rights, but all this is still up to you to police and enforce. Part of this comes in my counseling with people talking about the business plan. In a business plan, you want to set aside funds to obtain your rights, but you also want to set up funds to enforce your rights. And enforcement of rights is sometimes as much or many times more expensive than obtaining your rights. So those are important factors to realize right off the bat. With that, I wanted to go to the source, and I wanted to come back to this. These are the main URLs to get the sources, but I wanted to come back to that if I can, and go to a couple URLs here. USPTO.gov. Landing screen has some very good basics, how to maintain, how to apply, some application assistance if you're doing this pro se. And I see that I've lost screen share, so let me try this again. I think I'm back with screen share. Excellent. So the USPTO Patent and Trademark Office, oddly enough, patents and trademarks are in the same office, even though they derive from different constitutional provisions. And of course, it shows that the trademark basics have very similar look and feel. Trademark basics, how to search, how to apply. The copyright landing page is actually run out of the Library of Congress. They have their own IT department. They have their own setups. A little bit different look and feel for copyrights. Information on copyrights are called circulars. I'm not sure why, but they have all kinds of foundations of copyright informations, office practice and procedure circulars, and even they have an update grid and matrix of which circular might give you information that you're looking for. As I mentioned, trade secrets are a bit more different. Those are run almost strictly state by state. Here is a screenshot of Ohio laws and rules for Ohio's implementation of what was called a Uniform Trade Secrets Act definitions. And this then leads into other items of trade secrets. With that, I am done.
Wonderful. Thank you so much, Ed. I see that we don't have any questions so far. I, again, want to encourage anybody. We'll take a couple of seconds right now. If you have any questions about the basics that Ed just went over, or if you want to think about it and present it at the end, that's fine as well. Not seeing any questions pop up. I am next going to turn it over to our wonderful Claire, and she is going to be talking to us today about legal issues in fashion law. So bonjour, and thank you, Claire, for joining us again. I'm sorry, I just think it's cool that you're joining us from Paris. So take it away. Thanks so much.
Thanks, Jessica. Yeah, we're making this very international. So let me just try to share my screen. Is everyone seeing it all right? Okay, perfect. So with that great introduction and so much detailed history that Ed has given us, I wanted to transition this into something that we are more familiar with, and that is why I chose fashion law, because everyone, no matter if you're creative or not, participates in the fashion industry. No matter who you are, what age, where you live, we are all part of this industry and we can't escape it. So I thought it would be a good way to transition. In the fashion industry, there are a lot of legal departments that come into play. There's, of course, intellectual property, which is what this presentation will focus on. But there's also contract law, labor and employment, immigration, real estate, international trade, and government regulations. So with trademarks, we are given the definition that it has to be any word, name, symbol, or device that is used to identify and distinguish a good from something else. So as you can see, Prada, Chanel, Gucci, Louis Vuitton, you see these logos and you know immediately where they come from, what kind of company it is, and what kind of brand it is. You know immediately the price range it's going to be. So you see that trademarks in itself have value. A logo has a value, so it is important to protect it as an international company. Then we have copyrights, which of course is like what Ed said, it has to be an original work of authorship, it has to be creative, but it also has to be tangible, which means it can't only be an idea. So it also has to fall into one of these 8 categories: literary works, musical works, dramatic works, pantomimes, pictorial, graphic, sculptural works, motion pictures, sound recordings, architectural works. So we see that fashion is not included in any of these categories. So it makes copyright a bit more difficult when it comes to fashion, because copyright also you can't copyright anything that is functional. And as you know, clothing, shoes, sunglasses, bags can arguably have a functional use to them. So there's a huge issue with copyright and fashion, but that's for another time. And then we have trade dress, which is the design and shape of the materials in which a product is packaged. So over here we have the very famous Birkin bag by Hermes. So as soon as you see the design and shape of this bag, you know what bag it is, and that is why it is a trade dress. And we have the patent, which is a useful machine, a composition of matter, just any improvements. So if you come up with a new fabric, my friend recently made a fabric that can eat plastic and release oxygen. So things like that would fall under patents. Now let's go a little deeper into trademarks. With trademarks, you have to have an actual intent to use, or it has to be actually in use at the moment. It also has to be distinctive, which means it can't be very similar to a trademark that already exists. And like I said, it has to be non-functional, and it cannot be in any of the can't be trademarks categories, which we'll get into later. And in order for you to determine what trademark is good and what trademark is bad for if you ever want to start your own company or your own brand, this is the category, the top being the best and the bottom being the worst. The line shows where you can trademark and where you cannot trademark. So above the line where you can trademark, the best thing is fanciful, a word that never existed before. Those are easy to trademark and very easy to defend and enforce. Arbitrary trademarks are things that are not normally associated with the word that it is defined as. So for example, apple is a fruit, but now we associate that as computers and this whole other tech industry. So that is an arbitrary trademark. The next level is suggestive, which is something like copper tone. You can kind of guess from the name what the product is going to be. And here it's sunscreen or bronzer. And finally, descriptive with secondary meaning. If it is descriptive, it usually cannot be trademarked. For example, American Airlines, you know exactly what that is. However, after many years, it could develop a secondary meaning and consumers can automatically relate that trademark to the company. But the companies will have to prove this, so it might take some time. And on the bottom, again, we have descriptive without secondary meaning. You cannot trademark those, or generic trademarks such as light beer for light beer cannot be trademarked. And this is the list of the trademarks this is the list of categories of things that cannot be trademarked. So any living person's name without consent, any marks that are very similar to something that's already famous, any government's coat of arms or flags or insignias. And all the way at the bottom, we have immoral, deceptive, or scandalous marks, which we will talk about in a second. That used to be a requirement, but from now, that is no longer the case. And in this FUCT case, we have this LA brand called FUCT, and they applied for a trademark, and of course they were denied, saying that the trademark office said it was too scandalous. But because of a previous case, they were able to argue that we are pronounced FUCT, and this is our First Amendment right. You have no right to not let us trademark our brand. So now FUCT is an officially trademarked Los Angeles fashion brand. And we have the very famous red bottom sole shoes that everyone knows of. And I'm guessing everyone is thinking that these are the Christian Louboutin shoes, but actually those red shoes are Yves Saint Laurent shoes, and they are not Christian Louboutins. So, of course, Christian Louboutin sues Yves Saint Laurent, saying that red bottom-soled shoes are their trademarks and they can't do that. The court came, and Yves Saint Laurent was kind of smart, because in that line of shoes, they made that the top of the shoe and the bottom of the shoe were the same color. So you see blue on the top, blue on the bottom, green on the top, green on the bottom, and red on top and red on the bottom. And the court decided that Louboutin does have trademark on the red bottom sole as long as the top color and the bottom color are different. So it is possible for you to trademark a color. However, you really, really have to prove that this color is something that consumers automatically and really strongly associate with your brand. So we have things like Louboutin red, Coca-Cola red, we have John Deere green, UPS brown, Barbie pink, Tiffany blue. So these are all colors that you know immediately what brand they come from. And now we have the very fun case of parody and inspirations. Are you allowed to make a parody by using another company's trademark? So in this case, there's this company called My Other Bag, and they make very cheap canvas tote bags, where on the one side has a very famous expensive bag, and the other side it says my other bag, as in I left my other bag at home. So Louis Vuitton, of course, was not happy and sued My Other Bag. My Other Bag said, this is a parody. We all know this isn't the real Louis Vuitton. No one is going to carry gym shoes and carrots and groceries in Louis Vuitton bags. Come on. And the court agreed. The court said, yes, this is parody. You are allowed to make parodies. You are allowed to be inspired by trademarks. Again, you just have to make sure that you don't infringe upon the company's trademark too much. And we have our final topic on counterfeits. As you can see, counterfeits are a huge problem. 14,000 fake Nikes were seized in LA. And you see here that there are almost 500,000 jobs lost in the European Union. Annual sales lost is way too much. And you see the top 5 sectors for lost sales mostly comes from clothing and cosmetics, which is very much fashion related. So keep this in mind the next time you think about buying a counterfeit bag, all the jobs and the money that could be lost. And yeah, this is the end of my presentation.
Awesome. Thank you so much, Claire. And I'm still seeing no questions. There's got to be questions. That was a really good presentation on the basics and protecting your work and helping others. So feel free to add the questions at any point. If there are none, we will, in the interest of keeping things moving, we will toss it over to Katie, who's going to talk about something incredibly important for everybody to think about, social media for creatives. So Katie, take it away.
Terrific. Well, thank you so much, Jessica. First of all, can everyone hear me and see the slides that I'm sharing on the screen? Awesome. Okay. So in an effort to try to be respectful of everyone's time, I'm going to do my best to whiz through this material, but certainly if there are questions, we'll do our best to reserve some time at the end, and we're certainly open to, please feel free to reach out to any of us if you do have questions after this presentation concludes. So, I fully expect that most, if not all of our guests who have tuned in today are aspiring artists, creative people who are really trying to get a foothold, within their creative community. And one way to do that, or certainly an easy way to do that, and to try to raise your profile within your local creative community, is to take to the internet and share your work. Truly with a global audience via the internet and various social media platforms. But there are certain risks that are associated with sharing your work digitally online. And so the point of this presentation is there are really 3 topics that I would like to share over the next couple of minutes. The first is, as an aspiring artist, someone who's an emerging talent, what are your rights? Trying to lay a bit of a foundation to understand, what intellectual property rights vest in your work. And then secondly, the first of 2 topics, trying to offer some practical advice for, okay, now that you understand what your rights are and what the limitations are, what are some smart ways that you can go about sharing your creative work online? And then secondly, focusing particularly on social media sites, what are some smart ways that you can use those social media platforms to share, but also, practical ways that you can try to protect your work, but then also understanding the terms and conditions that are associated with your use of those online platforms. Okay, so first things first, we're going to try to set the stage here for what rights you have, as a creative person, and specifically, I'm focusing on what copyrights are available to you. So, first things first. To have a copyright, what exactly does that mean? What is in that realm? And both Claire and Ed kind of touched on this, but essentially you can get a copyright for a work that is original. So that sort of begs the question, well, what does original really mean? This is a word or concept that's really open to interpretation. And what the courts have said is that really a work that has a modicum of creativity, so even works that have just a little itty bitty bit of creativity, those are still eligible for copyright protections. So, you don't need to be, Leonardo or Michelangelo or, Prince or something like that in order to, to make something that blows everyone's minds. That you can create something with even just a small amount of creativity and still be eligible to get copyright protections for that expression. So the other thing too is it's important to recognize that originality and novelty are two separate concepts. So in other words, you don't have to be the first person to come up with an idea to still have a work that is original enough to merit copyright protections. So you'll see on the screen there, I've shared just a relatively random smattering of images of the Eiffel Tower in Paris that have all been taken from, shout out to Clare, that have all been taken from roughly the same angle. So here's an example of where you have a bunch of images that are not novel, so everyone has kind of come up with the same idea. However, each image is arguably original in the sense that each has been taken from a slightly different angle. They were taken during different weather conditions at different times of day with different passers-by in front, crossing in front of the frame. So arguably, even though this is not a novel view to shoot, there's still a certain amount of creative expression in each one of these photographs because the photographer had to make certain creative decisions about, when and where and how they took this photograph. Okay, so not only does your work need to be original or have that teeny little bit of creativity in order to qualify for copyright protections, but in addition, the work also needs to be fixed. So what does fixed mean? Essentially what that means is that your work needs to be recorded in some permanent or semi-permanent format. So to fix, a drawing is fixed the minute you put pencil to paper, right? Your drawing is now in this kind of permanent or semi-permanent format. When you compose a poem on your word processing software on your computer and you hit save, that electronic file is a form of fixation. By contrast, if you were to, for example, get on your soapbox in public square in downtown Cleveland and deliver an extemporaneous political speech, that is not a fixed expression. It might be completely original, but it's not fixed unless you were to, for example, write it down. So it's only at that point that that expression would be eligible for copyright. So you need originality and you need fixation. Now, Claire touched on this, but what types of works are eligible for copyright protection? Well, literary works, dramatic works, choreographic works, motion picture films, music, and that includes both the composition, the musical composition, and any lyrics that are associated with that composition. And then finally, visual arts. Paintings, drawings, sculpture, and also works of architecture are included in that as well. All right, so great. So I'm a creator. I have made this original fixed expression. When do I get my copyright? Like at what point does my copyright vest? Like when do I actually get that copyright? And the answer is as soon as you have fixed that original expression, you have a copyright. So it's important to understand that you do not need to register your copyright with the US copyright in order to have copyright protections in your original expression. As soon as you fix that original expression, right? Like as soon as you make that drawing, that original drawing, drawing on a sheet of paper, you have a copyright in that drawing. You don't need to register it with the federal government or with a federal government agency. So then as a copyright holder, what rights are you entitled to as that copyright holder? And you do have, there's a certain universe of exclusive rights that you alone as the copyright holder are entitled to. Now, it's important to mention that you as the copyright holder also have the authority to license permission to other people in order to, give them permission to distribute, copy, etc. your work. But the point is that you as the copyright holder have that exclusive right, and folks need to come and ask you for permission before they just willy-nilly go and copy and distribute your work. So you have the exclusive right to reproduce your work, to distribute it, if it's a dramatic work or a musical work, the exclusive right to perform it, if it's a visual work, to display your work. And then finally, to prepare derivatives. And one way to kind of think about a derivative is to think about sequels. So let's say, for example, that you're a big fan of Harry Potter and you want to write a work of fan fiction that uses the Harry Potter characters and some of the plot elements. That is an example that would sort of be considered a sequel to Harry Potter, a derivative work using those copyrighted Harry Potter characters and plot lines. And so you would need, in this case, the copyright holders, J.K. Rowling's permission in order to create that derivative work. Like that is one of the exclusive rights that she holds. All right. And so, just because you have a copyright in your work, does not make you the master of the universe. There are to what you can, there are limits on the powers and the rights that you get as a copyright holder. So one of those limits is a time limit. And it's quite a generous time limit, but it's still something to be aware of. Your copyright lasts for your lifetime plus 70 years. So it's a generous timeline, but you should be aware that there are some time limits. The other thing, and Claire touched on this in her presentation, but you can copyright your original work, your expression, but you cannot get exclusive rights via your copyright to the underlying facts and ideas that underpin your creative expression. So I can draw a picture of a tree and I can get copyright protection for that drawing, but my copyright does not give me ownership control over all trees. So just because I have a right to my drawing of a tree, I don't have the power to restrict other people from using the idea of trees or other people making drawings of trees themselves. So you get protection for the expression, but not the underlying concepts or ideas. And then finally, I think both Ed and Claire brought up this concept of fair use. We could devote an entire hour and more to talking about fair use. But what I'll say is that, again, even though you're the copyright holder, you cannot restrict others from using your copyrighted works under certain circumstances. So for example, if you're an educator and you're using someone's copyrighted work for educational teaching purposes, that qualifies as fair use. You cannot pursue them for an infringement claim. If there's a reporter who is writing a critical piece about, a show that you performed or a play that you wrote or a work of art that you put in a gallery, that criticism counts as fair use. The same goes for, Claire brought this up, but parodic works, people who are poking fun at something that, you've created, that again falls under fair use, and your exclusive rights do not extend that far, to the point where you can restrict those types of fair use.
Hey, Katie, sorry to interrupt your flow for a second, but this actually seems like a perfect place to address one of the questions that we've gotten. This actually comes from our host, DeAndre. We're going to take this video, and throughout our presentations, we've used various logos and the video for the Velcro video. When we upload this video and make it broadly available, both through the VLA and through In Education, are we worrying about fair use, or are we infringing anybody's rights?
So, I offer this purely as commentary. This is my own thought. This is not given as any kind of legal advice.
As Ed mentioned, you are not our lawyer.
No, I have not analyzed the specific issue, so this is just purely off the cuff. But I think we would have a strong argument that, obviously this whole entire presentation is for educational purposes, right? Like, we are here to present and to hopefully teach and and help out the artists who participate in Battle of the Teal and all of the other, maybe attorneys who are tuning into this presentation to try to get, a grounding in, some of these intellectual property concepts that apply to creatives. So, I think we do, if someone were to challenge us on, some of our uses of borrowed material for the purposes of this presentation, I think we would have a strong legal argument to say that this is fair use because we're using it for teaching purposes. So that would be my response.
Thanks, Katie.
Okay, good. I see DeAndre cheering, so I'm very, very glad to see that. Okay, so with just the couple of minutes we have remaining, now that we've kind of gotten, we've laid a little bit of a legal foundation, I want to address some practical tips for, okay, well, that's great. I'm an artist, I realize that I have certain rights, but there are certain limitations to that. How do I actually go about and share my stuff on the internet, and, try to get some, garner some attention and some interest in my work, while also, trying to, protect my rights as well. So a couple of tips and tricks for how to share your work smartly online. So one thing that you can do is to give people notice. If, for example, if you're sharing a visual work, you can say, hey, I have a copyright in this. This is a fixed expression. It's an original expression. I am declaring to you, anonymous user on the internet who's maybe looking at something that I've posted. I am making it known to you that I have a copyright in this work. And while certainly it won't necessarily, that alone won't prevent someone from copying or sharing it, it might give a user pause before they just go ahead willy-nilly sharing your work with other people, or in other ways that you have not sanctioned, by showing that you take your intellectual property rights in your own work seriously, by providing that notice on your work. It might encourage other people to approach you directly before they to ask for permission before they just go ahead and use your work. So an example, arguably, these very PowerPoint slides that I'm presenting to you right now are arguably copyrightable because they're fixed, because there's a modicum of, and I stress modicum of originality in these PowerPoint slides. What I could do is run a banner along the bottom of each one of these slides with the copyright symbol, the year that I presented these slides, which is 2020, followed by my name. So you can, depending, if it's a musical work and you're distributing, discs of that work, you can, put that that copyright notice on the front of your disc as well. You can find ways to give people you're sharing your work with notice that I am the copyright holder. The other thing too is just, careful not to give away the story. We're artists really, so frequently just want to get the word out and, share their work with others. But it's important to do it thoughtfully. So, for example, one thing that you can do if it's a visual work of art that you want to share is to watermark the image. And so an example of that is on the screen, where basically you have the semi-translucent text. This could be your copyright notice that you have running over your image. And again, it's a way of sharing your work with other people, but discouraging them from just downloading and sharing the particular digital file that you have chosen to share on maybe a personal artist's website. Another thing is share lower resolution images of your work. So if someone does want to go ahead and copy it, they can, but it's going to be really hard for them to like slap your painting on a t-shirt or a coffee mug or a greeting card and try to sell it, because what you're sharing publicly is so low resolution that it discourages infringing uses. You can also, try to provide some contact information that does make it easy for other people who might want to use your work to get in touch with you and ask for permission. By no means am I advocating putting all of your private, contact information on the internet, but maybe you can create a professional email address and, post that on your personal artist website and encourage people to get in touch with you there. That can help and encourage people to ask permission as opposed to just helping themselves. And then finally, another idea is just make strategic choices about what and how much you're sharing. So maybe rather than sharing a full song file, an audio file on your band's website, maybe just share a snippet. Or if you're a visual artist, maybe you can show your work, but maybe you can show it at kind of an angle, or you can choose what types of images you're presenting, again, so that you can get the point across of what your work looks like, but you're not uploading an image that will kind of entice someone to want to like really copy and distribute like that image itself. And then, there's, Ed kind of mentioned this, but, the onus is on the artist to police and monitor how their work is being shared and really to enforce their rights. So, one thing you can do is set Google alerts. If you're a musician and you've written a song with lyrics and you want to kind of track how your song is being used online, you can put the song title into Google Alerts or any sort of key lyrics, and you can sort of monitor how your song is being talked about online. Again, just because people are talking about your song does not mean that is copyright infringement, but it will just give you an opportunity to monitor that use online and take action if necessary. Also, reverse image searching if you're a visual artist. That's a great way to kind of track how your work is being circulated online. But again, I caution you, pause for a moment to consider whether the use that you're observing online actually constitutes fair use. So before you go send a nasty gram to someone who's maybe using your work, stop to consider, is this criticism? Is this reporting? Is this an educational use? Because folks do have the right to do that. And then finally, to hopefully bring this home, just a couple of practical tips for using social media and sharing your creative expression via social media. So question number one is, if I go ahead and share something on Facebook, Instagram, etc., do I still, have I somehow surrendered my copyright to that work? And the answer is no. I mean, obviously, I cannot speak for every single social media platform that exists, but, based on my review of the terms of use for the major platforms, what they go ahead and say is that, no, you retain your copyright to whatever work you're posting on our site. However, you are granting Facebook, Instagram, Twitter, etc., a license to store copies of your image on their servers. They need to do that in order to make their service run. And say, for example, Facebook wants to run a commercial and they want to, show examples of some of their users' posts. Well, if you're a user and you post stuff, then Facebook can, maybe use, for example, one of your posts in some TV spot without notifying you, without paying you, because under the terms of use, you have granted them a license to do that. If you're not comfortable with that, then you should think twice about, whether and how you want to use social media. But the point is, inform yourself, make sure you pay attention to those terms of use and that you're comfortable with them. Take a look at that in advance. I'm going to skip those slides. One other thing to be aware of, not only terms of use on social media, but community standards. So many social media platforms, in an effort to, restrict really ugly behavior like like child pornography and, exploitation of children and things like that, they have certain community standards. For example, there are restrictions on posting nudity. Obviously, lots of artists, who do life drawing, drawing from live models, oftentimes nudity is a part of a lot of art. So you should just be aware that Facebook, for example, has certain community standards that say if it's a work of art and there's nudity, we permit that. But again, ultimately there are human beings who are behind these, the monitoring of, the compliance with these community standards, and people make mistakes, and sometimes your page can get blocked, for non-compliance with those community standards. So if that's a problem, maybe just be careful about, the subject matter, depending on the type of art that you make. Just keep those community standards in mind, just to avoid, potentially having your account blocked, shut down, even temporarily. Okay, and then, again, by sharing your work online, you're potentially reaching a really wide audience, but at the same time, there's the risk, you're giving up a certain amount of control over how your work is being used and shared by other people. So just because you're sharing your work, with your friends only, your own contacts, doesn't mean that one of your friends couldn't then just post your posting, completely publicly. So it can be sort of hard to control the proliferation of, how of your images or your sound files, etc., how these things get shared beyond your own kind of initial community. So again, what do you do about it? Well, I would refer you back to those monitoring and policing mechanisms, setting those Google alerts, running those reverse image searches. So again, you can do your best to try to monitor uses and try to, send cease and desist requests to those people who might be infringing on your copyright. And with that, I will be happy to address any remaining questions. And if you have further questions and would like to get in touch, I certainly welcome you to reach out to me as well.
Awesome. Thank you so much, Katie. So I know that we are supposed to go to 7:30, but we did start a couple of minutes late. So people do want to hang on just for a couple of minutes. We had some questions come through, and I think most of them were addressed through your presentation and yours and Claire's. And Ed's and Claire's, of course, as well, too. We did get one question from a viewer who says that she started a company and registered it in Virginia. I'm assuming it's a company related to the arts. We might need some clarification with that. But years later, the company stated or started their product with the same name, similar logo, and then they took the URL once the domain name registration had expired. Now, with the caveat that nobody speaking here is anybody's lawyer, is that something that you, in general, would encourage somebody to take action about? Can go to any of our speakers if you want to speak.
Just to make sure that I understand the fact pattern here. So we've got a business owner started a business in Virginia. Somehow this business apparently went dormant, and another competing business started creating a similar product or offering a similar service, and then eventually was able to capture the first business's URL once they discontinued that their ownership of that registration. Do I have that right?
Hopefully so, coming in from the question, but our questioner, if there's any follow-up that you wanted with that too, yeah, it is a design company.
Well, so my first just reaction is that, if in order to, and Claire's welcome to jump in here too, because her presentation focused on trademark, but trademark is a source indicator, right? So a trademark, it tells consumers where a product has come from, like who has put this out into the world. And so, and part of part of trademark ownership is that you have to still, in order to claim a trademark right in, you know, a logo or a business name, et cetera, you have to be actively engaged in that business. Like, you have to be actively engaged in making that product, offering that service. If you're no longer doing that, then you're not a source of a good anymore. You're not a source of a service anymore. And so it's harder. I think you're going to have an uphill battle of trying to claim that, you know, yes, like I remain an active user of this trademark, and therefore, you know, I have maintained my rights in it, and you, competing company, are not allowed to use it. So I think it would really, you know, depend on, it would just sort of depend on the facts. But that I'm seeing now that the commenter has written a follow-up to say that he or she is in a different area, and that this competitor is in like a different geographic area. This can get really complex really fast, the geographic limitations. So I guess I would ask the questioner, you know, is the reach of your company a national reach? Like, do you have customers all over the United States, or are your customers based, for example, in Ohio, versus your competitors' customers who might be based in Florida? You know, if that's the case, then you might have regional rights to use your particular trademark, but you might not have national rights to do so, in which case, you know, you're not going to be able to you know, pursue an infringement claim against that person who's operating in a completely different region. So, you know, Bob's Burgers, right? Like, you can be Bob's Burgers in Cleveland, Ohio, and, you know, there can be some other guy named Bob in California who opens a burger joint. You, Bob in Ohio, you can't stop that guy in California from doing that, unless, of course, you have franchises all over the United States, unless you've registered for that federal trademark. Things like that. So, you know, if there are some kind of geographical issues there, I would really just encourage, you know, the person who wrote in, talk to an attorney, and, you know, lay out the facts, and, you know, try to get some advice, and yeah, and try to sort through it with an attorney.
Well, that sounds like the perfect place to wrap up and say, since we are the volunteer lawyers for the arts, contact an attorney. For those of you who are in the Cleveland area, or like I said, in the Northeast Ohio area, and you would like to seek some legal help, please scroll back to my email address that I posted at the beginning of the chat. Send me an email. We're happy to give you an application and see if the VLA can help you. If you're outside of the Cleveland area, I strongly encourage you to contact your local bar association. Almost every single bar association across the country has a lawyer referral service where they can refer you to somebody either for very low cost or free of charge to get a consultation and see if that's any legal matter that you want to take any further. We always will say, try to get an attorney who is practicing in the state or area where the issue took place. So if your business was in Virginia, get a Virginian lawyer. You know, we did mention that a lot of these protection issues are a federal issue rather than a state. Still is always a good idea to check with an attorney who is familiar with the laws where the issue took place. With that, I will say thank you so much again to our host, DeAndre in Education. Thank you to our panelists, Katie, Ed, and Claire. You've been amazing and wonderful. We encourage you to stay in touch with us. We're going to be doing more presentations on lots of other issues, and we really want to reach out and help the public as much as we can in general, and especially in these times under COVID. We want to make sure that we still keep helping the arts community keep us strong and vibrant. Have a wonderful evening, everybody. Thanks again, and we will talk to you again soon. Take care.
So long. Thanks so much.